good afternoon, everyone. As Kathy said, welcome to our weekly webinar series on COVID-19 issues. I'm going to give everyone just a brief overview of our agenda today. We're going to talk a little bit about reopening as we have been in recent weeks. We're going to start off with, kind of where we are because there's a lot happening virtually on a daily basis. And then we're also going to try and take a look toward the future for you. So, kind of a prognostications about where we're going and where we might be, down the road. One of the questions we've been repeatedly getting is liability issues with people reopening. What are the concerns? And so we're going to talk a little bit about that today. We're going to talk about the safe workplace and OSHA related issues. And then finally, another update on the PPP program. That seems to be in a constant, state of flux. I think there have been less development, so we can take a little inventory today and bring you up to date. So with that, let's start with Adam Mastrolio. Adam is a member in our Syracuse office, and he's going to talk a little bit about where we are with reopening.
Pete, thanks so much. Today is a great time to start talking about where we are because just over 1 month ago on May 15th, businesses around the state were allowed to open, or in parts of the state were allowed to open in phase 1. So we've had a month now to digest the information and the guidance that the state has been providing to us. And we are in a much better place in terms of what we know we need to do as part of the reopening process. Kathy, if you could, next slide. So what I want to talk about briefly are some of the reopening fundamentals, things that we know or we've learned over the past month we need to do as part of this reopening process. And I want to talk a little bit about each of these and maybe go into a little bit of detail. But first of all, I think it's very clear that any business that was closed and that wants to reopen or that has been operating all along as an essential business needs to perform a risk assessment. We've talked about these risk assessments before, but you really need to sit down and critically think about where in your business the risk of transmission is. So if you're a manufacturing facility, you look at your manufacturing floor, you look at the offices that you have, you try to figure out where is transmission likely to occur? Where are we going to have employees close to one another? Where is there going to be interaction with customers or vendors or third parties? So every reopening needs to start with an analysis or an assessment of your risk. Next, you're going to have to read and understand the specific guidance that the state has put out for your industry. Hopefully, you're in an industry where there is specific guidance. And I think a couple of things are important here. You will need to figure out where you fit in. So are you within one of the phase 1 categories, industries? Are you within a phase 2 industry? Are you within a phase 3 industry? Complicating matters is that one business can have many or more than one sets of guidance that applies to them. For example, a construction company has construction activities, and the state provided specific workplace safety guidelines for the construction industry. But the state has also provided guidelines for office settings. And if you're that same construction company and you have an office setting, then you're also going to want to read and understand the guidance that's applicable to office settings. The state has made it clear that if you are one of those businesses that has more than one industry within your business, such as construction, you're going to have to make sure you're complying with both sets of guidance. Now, we know when I say review and understand your guidance, we know that the state is providing several sets of documents, 3 to be specific, 3 sets of documents for each industry. So, for example, in the manufacturing industry, they provide summary guidance, detailed guidance, and a copy of the template that they've put together. It's important to understand the difference between these documents. The summary guidance is a nice, simple chart that will show you within your industry what is required and what are best practices. So that document is a great place to start to try to understand what New York is requiring for you to do. The detailed guidance goes into more detail, as the name implies, regarding specific information or specific things you need to do, but it also provides more substance on recommended actions. The detailed guidance does not distinguish between required and what is best practice, other than to use the words must or shall, as opposed to may or should. So the detailed guidance will provide you with a little more detail, but I think the summary guidance is great for understanding what's required as opposed to what a best practice might be. Now, the state is providing this guidance and information in all of the phase 1 industries, all of the phase 2 industries, and now all of the phase 3 industries. So for each of those industries, you'll see those 3 links. And Hermes is going to talk about that a little more later, but it's the summary, the detailed, and the template. Throughout the past month, the state has also released guidance that is applicable to industries statewide. So for example, the state released guidance for child care and day camps just recently, dentistry, racing activities, auto racing. So these are statewide industries and statewide guidance that isn't part of the phase 1, phase 2, or phase 3 guidance. So all of that is located on the state's website, but it's separate. Importantly, the state recently, just last week, released guidance for special education. I'm sure many of you are aware that the governor permitted special education, in-person special education, to begin. But the state didn't put the special education guidance in the same place it's been putting the statewide guidance or the phase guidance. The state released separate guidance for special education from the Department of Health. So it's in understanding and reviewing New York State guidance, you have to understand and look for the guidance that applies to you. Now, if you're an essential business, we've been saying this all along, but it still rings true. If you are an essential business that is operating and has been operating, but you don't fit within any of the statewide guidance or the phase guidance, you still have to try to comply with the general tenets and general requirements that the state has put out. And this is confirmed in the FAQs with respect to the guidance. All right, next, after you've reviewed and understood the guidance that applies to you, you need to develop a workplace safety plan. And we have talked quite a bit about these workplace safety plans and what needs to be included in them. And I'm not going to go through exactly everything that needs to go into these plans, but just as an overview, you have to have occupancy restrictions, PPE requirements, cleaning and disinfection, screening, etc. All of these things that the guidance is going to tell you has to be in your plan. You have to put together a plan. One note about your workplace safety plan, be careful using the template. The state has put out a template that applies, that it is saying can be used in all of the different industries that are out there. But there are many requirements that are specific to industries that aren't mentioned in the template, nor could they be, because they're a template. So just be careful when you're using the template. For example, the guidance on childcare and day camps has an entire section of required elements to your workplace safety plan that aren't found in the template. These required elements deal with specific activities and how you're going to put on these specific activities. So just be careful with the templates. If you have a question about a workplace safety plan or a requirement in the guidance, make sure you're getting counsel. Call your bond attorney. Ask them a question. It's not going to be cost prohibitive for you, and the clarity and peace of mind is certainly worth it. So reach out to your bond attorney. Now next, you need to communicate and implement your workplace safety plan. This is pretty self-evident. The workplace safety plans themselves require a communication plan, but I put it separately because it really is another step in the process. And last but not least, you have to affirm that you are complying with the New York guidance. This affirmation is completed online. You go onto the New York State website where your guidance is located, and you click on the link, and you can affirm that you are going to comply with the guidance. So this is just a general overview of the fundamentals of reopening that we now know we're fairly sure, we're fairly certain this is how you're supposed to do it. This is what the state has been telling us now for a month in several different areas. So that's it, Pete.
Adam, real quick, we've had some questions about face coverings here, and kind of the principles, and I think they vary a little bit again by the industries that we're talking about. But general rule is that you need to maintain social distancing, and if you cannot maintain the social distancing, then face coverings are going to be mandatory in those situations. Is that a fair statement?
That's correct, Pete. And then with respect to certain industries, you're going to have different requirements. So for example, for the office workplace safety plan, you have to make sure that face masks are worn in common areas such as hallways, elevators, etc. So yes, that's a correct statement of the general principle, and then you're going to want to look at your specific industry guidance for more details.
Great. Okay, thanks. So that's kind of where we are, which is complicated and tricky, but I think we're tethered or grounded by, the common principles, and a lot of this can be dealt with through those. A sort of a look of where we're headed. Hermes Fernandez, a partner in our Albany office, is volunteered to give us his insights as to where we're going.
Thank you, Pete. Maybe we can slide to the first slide here. When my younger daughter got her license, her driver's license, about the second day she had her license, she called me up and she was lost. And she said, I need directions. And I said, well, where are you? And she said, I don't know. And I said, I can't give you directions if you don't tell me where you are. And I got Dad. But, right, you can't know where you're going unless you know where you are. So where are we now? Well, we are in different places throughout the state, right? New York City is in phase 1. The Albany area where I am is in phase 2 until tomorrow. The governor announced this morning we'll be moving to phase 3. Much of the rest of upstate, central New York, Finger Lakes are in phase 3. No place in the state is in phase 4. And Long Island, I believe, started phase 2 yesterday. Let me just disabuse everyone of the notion that the phases mean a lifting of the restrictions. They do not. The phases mean a lifting of restrictions in certain industries and activities. We can go to the next slide and probably even to the slide after that. Where we are, nope, back, too far, back one, there we go. So where we are, right, is in different places throughout the state, but there's a commonality to all of this, which is the opening of industries by phases. Phase 2 is the big thing for all of us. When you get to phase 2, there's much more of a degree of normalcy, which includes the opening of outdoor restaurants. So where are we going beyond this? We are really, and I don't mean to minimize this, but I think this is actually an analogy all of us can understand. We are all in an adult game of red light, green light, 1, 2, 3. The governor is the moderator of the game, right? This game started with the governor saying red light. We were all held in check for quite a long period of time. And then the governor said, Central New York, Western New York, green light. The rest of you, nobody else move. We kept going back and forth. What we're seeing now is there's times when the governor is saying green light, red light, and then other times when he is doing it very slowly. We're all familiar with this process. We are now living it. So where are we going? We are going to a place where once we get to phase 4, we're not at the end. Phase 4 is probably the end of the beginning, but it is not the end of the end, right? We are going to be in a place where we are going to continue to live with restrictions. The restrictions will be many, but the restrictions, at least in the short term, will include the wearing of masks. I expect that to continue probably until we see a vaccine. We're going to continue with social distancing. That is going to go on at least until we get a vaccine. We're going to live with contact tracing and screening, because we are living in a world right now where there are, and I don't want to say no effective treatments, because we just heard this morning of a second of the beginnings of an effective partial treatment. Treatments are being developed. But right now, we're living in a world with no comprehensive treatment and no vaccine, and the only means to our personal safety is staying away from one another, right? And what we see in this great game of red light, green light is our governor and the governors of all the 50 states are trying to do two diametrically opposed things. They are trying to put out rules that keep us all apart and yet allow us to come together. So we are seeing things that look inconsistent, that look like they don't make sense. And that's all because there are two completely opposed goals here, all towards a goal of safety. I think some of the other things we're going to see, and we don't know exactly where these things are coming from, right? But as we get past our openings or get past some of our closings, right? We have things in place such as rent moratoriums, right? Those of you who are landlords are painfully aware of this, right? There are moratoriums on the collection of rents of commercial properties and personal properties. What happens when those are lifted? If I've had my restaurant closed for the last 3 months, my retail establishment closed for the last 3 months, where do I get the money to pay you the rent that you are owed? Are you as a landlord going to have to say to the tenant, sorry, you can't make these payments, you'll have to leave? I've had mortgage payments to make. Maybe your mortgage payments have been on hold. Property taxes, though, continue, right? I think that's going to become a huge flashpoint for us as we go forward in these next few months, sorting out the debts that have been collected and accumulated among us. We will continue to see in this red light, green light prospect, the governor taking steps to open things up, but at the pace he believes appropriate. The governor, it was a couple of weeks ago when the governor announced groups of 10 could come together. In the last couple of days, the governor announced that when you are in phase 3, groups of up to 25 people can come together. Right? That's fairly significant, right? But it is not big crowds. It's not big numbers. The U.S. Tennis Championship, the U.S. Open, held every year in Queens. Announcement today that is going forward. Announcement today without fans. The Belmont Stakes, the famous horse race, going forward, as all horse racing is going forward, without fans. We don't know when we'll see sports back, right? I mean, if I'm a basketball player, I'm not signing up for 2 months of quarantine, but that's what's being talked about for them to continue to play basketball. So what are we going to see? We're going to see continued restrictions. We're going to see continued need for safety. The plans that Adam was talking about will need to remain in place. You'll need to continue with those. You'll be allowed to tweak them as necessary, but the safety plans will remain in place. And everything I'm reading is saying we're in for this for at least the next year. So with that, Pete, I can conclude.
Thanks, Hermes. Appreciate that. And I think maybe it's something that we all really need to be thinking about is the medium and longer term living with this, rather than the idea that this is the beginning of the end. In any event, Dan Pouts is going to talk to us a little bit about liability issues as people do reopen. There are some concerns and some things to keep in mind. And so Dan is a partner in our Syracuse office. And take it away, Dan.
Thanks, Pete. Welcome to all of you. It's good to be back. I think this is my 3rd time on this webinar, and nobody likes to hear from me because generally if I'm talking to you, you're thinking about either suing or being sued. But that being the case, as the first 2 presenters have talked, there's a certain level of uncertainty that we just have to become accustomed with. One of those uncertainties is, what exposure do we have as a business that's operating now? What exposure do we have to potential liability in these unprecedented circumstances? So far, as of yesterday, I think nationwide, there's about 3,000 lawsuits that have been commenced related to COVID-19. And it really, across the board in terms of the types of lawsuits, the theories that are being pursued. Most recently, we've seen a lot of actions against colleges and universities, students that are seeking remuneration for the online education. The argument is that the online education that was provided in the second semester, that they didn't receive the benefit of their bargain, that it wasn't a comparable product to what they were promised in terms of as compared to in-person education. We've also seen a number of commercial disputes that are commenced. A lot of them focus on insurance coverage, particularly business interruption coverage, whether this pandemic is something that provides a basis for a covered loss under an insurance policy. We've seen a number of cases where the issue of what's called force majeure is at front and center, meaning, is this pandemic an act of God? So much so that you could relieve a party from their contractual obligations. So all of these claims and lawsuits are in the background, and they're all going to work their way through the legal system. And this 3,000 cases, about 25% of which have been filed in New York, I think it's widely believed that that is going to be the tip of the iceberg. We anticipate that there's going to be a number of additional lawsuits. And some of those lawsuits, for purposes of today, are going to be related to tort claims, potentially by an employee against an employer, or by patrons or customers of a certain business. As we enter this phased reopening that Adam and Hermes was talking about, employers we're concerned. They're justifiably concerned about what the legal liability is moving forward as we reopen. So I want to talk today a little bit, very briefly, about the types of claims that we've seen in that realm, claims that have been brought either by employees against their employer, or claims brought against businesses pertaining to the COVID-19 exposure or risks. We've seen recently the types of claims that are being filed by employees. We've seen a lot of WARN Act violations, where, as many of you know, it's the failure to provide the requisite written notice before terminating employees. We've also seen a lot of Fair Labor Standards Act cases. Some cases, although not as many, of assertions of to entitlement to compensation for canceled events. Performers specifically are saying, well, it's not my problem that the event was canceled. I have an expectation and a contractual promise of payment. We haven't seen a lot of negligence actions yet. And that's what most of you, I'm sure, are concerned about. And that's what a lot of us here are looking into and trying to anticipate when those cases are going to come, and what the theories of liability and, of course, defenses are going to be for those claims that are likely to allege either exposure to COVID-19 at a place of business, or at least a heightened risk of exposure. The cases in that area that we've seen so far, they're mostly requesting what's called injunctive relief. In other words, an employee or a group of employees, they file a lawsuit, and they're alleging that their risk of exposure to COVID-19 in the workplace is heightened because of an employer's lack of adequate protections in place. And they're not asking the court for monetary damages, meaning money. They're asking the court to order this business to implement certain restrictive or protective conditions. One of the cases that I looked at yesterday was, there was a number of allegations by the employees. It was the failure, there was no screening process in place for folks entering the workplace. There was no cleansing or sanitizing standards. There was no inadequate personal protective equipment that was provided. So these plaintiffs were asking the court to order the employer to implement those policies. We don't know how many of these such cases are going to come up. And we don't even know if there's going to be this huge wave of negligence cases for a number of reasons, which I'll touch on. But in anticipation of the possibility of that happening, we need to be very mindful of what our defenses or possible defenses are going to be. The first and the best defense, unquestionably, is you are in compliance with all state, federal, and local guidance. Adam did an excellent job of going through all of the various guidelines that are in place, where to find those guidelines, how to implement those guidelines, particularly as it pertains to a workplace safety plan. Be mindful of those, be aware of those, and be diligent in terms of enforcing those guidelines. Because in terms of a negligence claim, failure to be in compliance with this guidance is going to be strong evidence of negligence in the event that you are named in a lawsuit. So that's the first line of defense, is be in compliance with the guidance. The second defense that we anticipate, which is going to be very interesting to see how it plays out, is causation. In a negligence claim, one of the elements that you need to prove is that the defendant's lack of or failure to comply with reasonable standards caused you to sustain injuries or damages. In the case of COVID-19 exposure, as you may imagine, we believe it's going to be extraordinarily difficult for someone to prove a date, time, location of exposure to COVID-19. A good example of this is a lot of folks that were trapped, for lack of better words, on cruise ships, and they were infected with the virus there. It's fairly easy for them to argue causation because they didn't go anywhere else. They were on a cruise ship. They were locked in. So it's pretty easy to argue that that the causation was there. In other areas, for example, if someone is alleging that they were exposed to COVID-19 at a restaurant, for example, that person would ultimately have the burden of proving that the exposure took place at that restaurant as opposed to on public transportation or at a different restaurant or a different location. From a medical and evidentiary standpoint, we believe that's going to be extremely difficult. So that's the second line of defense that we're anticipating. The third, from an employer standpoint, is, of course, workers' compensation insurance. Workers' compensation insurance, workers' compensation benefits, rather, is the exclusive remedy for workplace-related injuries resulting from an employer's alleged negligence. Because of the causation issue that I just talked about a moment ago, it's still a little bit unclear whether workers' comp insurance is going to cover these claims, simply because we don't know if the Workers' Compensation Board is going to accept somebody's assertion that they were exposed to COVID-19 at the workplace. The same causation issue is in effect there. At this point, courts in New York have not decided that issue, whether it's a covered claim under comp insurance. But based on case law that we've seen in the past, we think there's a pretty good chance that it will be deemed a covered claim. A couple of examples that I found from the New York State Court of Appeals, which is the highest court in our state, they've upheld comp awards for tuberculosis infection based on a correctional officer's exposure to a sick inmate. We've also seen compensation awards upheld for aggravated asthma based on exposure to secondhand cigarette smoke. And in those examples, of course, those exposures could have happened elsewhere, but they were deemed to be a workplace injury for purposes of workers' comp. So a couple of things to keep in mind in terms of the workers' comp. There's a way, what the Workers' Comp Board has done recently is they've put guidance out encouraging employees that if they are infected and they are diagnosed or receive a positive test, to file a comp claim. And the board has also encouraged employers, if the circumstances permit, to make what's called a 21A payment, which is basically a payment of comp benefits without acknowledging liability. So those are the few things. It's follow the guidance. There's a workers' compensation bar, and then, of course, the causation. Those are the three defenses that we anticipate. Moving forward, I want to wrap up, but sort of the next frontier, and I expect the next time I'm on one of these webinars, there's really two issues that are going to be at the forefront coming up. One is whether or not there's going to be legislation, either in a state and or federal level, that's going to shield employees or businesses from liability based on COVID-19 exposure. I'm sure many of you have read about it. It's going to be interesting to follow that. The second is waivers. Waivers for employees, waivers for customers. We've seen waivers from colleges and universities for their student athletes. It's going to be interesting to see the extent to which these waivers are enforceable. So next time I'm on here, it's likely that I will be talking about that. Pete, that's what I have for now.
Thanks, Dan. Good point on the waiver discussion. I think we're getting a lot of inquiries, not in this particular Q&A, but generally speaking from clients on those issues. And, waiver is one way to approach it. Assumption of risk is another concept. But I think a lot of people are grappling with the issue of what it means to ask for a waiver or to engage in that kind of conversation. And it's now gotten a little bit of national attention, I think, with respect to, the Trump campaign's announcement that they would seek waivers in connection with some of their rallies. So a good topic for people to think about and for future discussion. Let's turn to Mike Billick. Mike's a partner in our Albany office. And, we tried to group these things today a little bit on the reopening side, and then, sort of on the what should your concerns be in terms of liability and exposure. And so Mike's going to walk us through some of the OSHA issues here in terms of workplace safety.
Gotcha. Sounds good. So been getting some questions from clients about what is the effect of OSHA? What's OSHA interested in? What's the possibility of OSHA doing an inspection for COVID protections and things of that nature? So OSHA can inspect your workplace for if there's an employee complaint. And sometimes what happens is an employee lodges a complaint with OSHA, and OSHA will send you a letter saying, we've received this complaint that you're not protecting employees from coronavirus or not taking precautions. So please send us a response. If you don't do so, we're going to do an investigation, or if we're not happy with your response, we're going to do an investigation. They don't necessarily have to do that. They could just go ahead and come in and do an investigation without sending a letter first. If you report an injury or illness due to coronavirus, they could come in and do an investigation because of that. They could also do it as part of their site-specific targeting program, but they probably wouldn't do an investigation focusing on coronavirus just due to the site-specific targeting program. It'll mainly be from an employee complaint or if you've reported an employee hospitalization. So what OSHA is going to be looking at are really, they have two main ways that they could issue a citation, things that they're going to be looking at. The first is a very specific way. There is a regulation 29 CFR 1910-132. You don't need to know that, but it requires all employees to give, requires employers to give their employees personal protective equipment that they need to do their job safely. So if you have an employee working on a construction site, or they should have steel-toed shoes, hard hats, hearing protection, things of that nature. When it comes to coronavirus, it could mean, especially if you've got an employee that is doing temperature checks, it could mean face shield, gloves, apron, things of that nature. OSHA did just issue a guidance document asking, are cloth masks, or are employers required to give cloth masks as personal protective equipment? And OSHA said, no, you're not. Under this regulation, you're not required to do so. We encourage employers to do so, but this regulation does not actually require you to give employees cloth masks. So the other aspect that OSHA could come in and focus on is their general duty clause. And that is a very broad statute as opposed to a specific regulation that requires all employers to have a workplace that is, in the magic legal language, is free from recognized hazards. So we now, all of us, recognize coronavirus as a recognized hazard. Of course, we can't necessarily keep the workplace free from the virus completely, but the obligation under that statute is to take feasible abatement measures to minimize the hazard to employees. So what feasible abatement measures do you have to take? Well, that's the issue. OSHA hasn't issued a regulation. They've announced they are not going to issue regulation regarding coronavirus. So it really is what is feasible, what is reasonable to your workplace. OSHA has issued a number of guidance documents. There's a comprehensive guidance document, and if you go on their website, osha.gov, the first item that pops up is their coronavirus subpage. You go on there and you can see the general guidance for all industries, and then a few times a week they come out with specific guidance for specific industries, and it is worth checking out. And again, I was asked this question even just this morning. Are we required to follow this guidance? OSHA can't issue you a citation for not following the guidance. It's just informal guidance. It doesn't have the power of a regulation or statute. With that being said, if OSHA comes in because an employee was in the hospital due to coronavirus, they are obviously going to be using that guidance as a template for how they conduct their inspection and looking to see what items did you consider, what items did you implement. So it's certainly something that you need to take a look at. Now, I've mentioned injury and illness reporting, and Dan did a good job talking about the fact that it's difficult to establish causation sometimes, unless you're on a cruise ship, in terms of was catching coronavirus due to the workplace. So, as you know, any employment-related injury or illness that results in a day away from work, a restricted duty, a job transfer, requires reporting on the OSHA log. But is this employment-related or not? And OSHA has issued a few letters and informal guidance stating that you do the best you can to really determine, do we believe this was employment related or not? I would say that if you are a healthcare provider and you've got people that have been exposed to a number of coronavirus patients, it's probably more likely if somebody catches it, it's due to that than something else. Whereas if it's in an office environment, nobody else has gotten it, you find out that other people have gotten it, it's more likely that they got it from someplace else. And you are able to ask that employee, just like a contact tracer would, where do you know anybody that had this, and things of that nature, to try to find out, is this employment related? Did you get this from the workplace, or did you not get this from the workplace? Now, the other aspect for injury and illness reporting, a few years ago, OSHA did change its reporting requirements. It used to be that you had to have 3 people, an accident causing 3 people to be in the hospital before you actually had to call OSHA to report that issue. Now it is just 1 person. If you do have somebody who is hospitalized, inpatient in a hospital, then you do have to report that to OSHA. You have to call OSHA, your local area office, call OSHA within 24 hours if you have somebody hospitalized due to an injury or illness. So if you believe that it's due to exposure from the workplace and somebody's in the hospital due to coronavirus, you have to call within 24 hours of that person being hospitalized. I will note that in terms of OSHA's enforcement activity, my old boss, the firm I was at before here at Bond, Gene Scalia, was on Capitol Hill last week testifying and taking a lot of fire because OSHA has not yet issued, has issued 1 citation for coronavirus or associated with coronavirus. So a lot of employee groups and union groups are asking and wondering, where is OSHA's enforcement efforts when it comes to coronavirus? And the 1 citation that OSHA has issued has been to an employer that did not report a coronavirus, employer-related coronavirus hospitalization within 24 hours. OSHA has not yet issued any citations under the general duty clause or under the personal protective equipment standard. That's not to say they won't do so. OSHA has a 6-month statute of limitations to issue citations. I would anticipate over the summer and into the early fall, we are going to see a bevy of citations as compliance officers and area directors issue these citations based on the inspections that they have been conducting, are conducting now, and will conduct in the near future. So, so that's what I have on the latest and greatest from OSHA and coronavirus. So I'll hand it back to Pete.
Thanks a lot, Mike. So we're getting a few questions that I think are trying to manage the interplay between these standards and the various obligations here. So let me take a stab, and Mike, I'll ask you to stay unmuted here so you can help me with it. But So I think we've got the guidance from New York State on how people, should be open, who should be open, and, sort of creating a floor for the practices that need to be in place if you are open. And then we've got OSHA setting its standards for PPE and, under the general duty clause for a safe workplace. And those two, New York may have, more specific standards in some cases. The face coverings, come to mind as one where, I think there's a little bit of difference between the two. So you're going to need to look at both as you manage going forward. And so then, Mike, the other thing is, if there's an issue, we've got the potential for, the Attorney General in New York to say you're not following the standards. We've got the potential for someone at OSHA, an area director, to issue a citation. We've got the potential for workers' comp liability, or, going to where Dan had said, we've got the potential for litigation if it involves, visitees, third parties, people like that. Anything, Mike, that you would add to that, or in terms of just trying to manage these varying, it feels like people are going to have a lot of balls in the air.
No, I agree with that. And actually, I had handled a case, I guess it's going on 10 years ago or so now, where there was a fatality and the company was facing an OSHA citation. The local district attorney was seeking criminal charges against the company, and the family was looking at a civil action, all for the same action. So they can overlap and be a lot of issues there, and facing it on multiple fronts.
Okay, I think that's a good summary of at least a lot of things to keep in mind. We're going to shift gears here a little bit and spend our remaining time with Kate Schimmelwick. Kate is in our Syracuse office. She has been presenting on, following very closely the PPP program, and I think this week, Kate, we get to take a breath at least. Maybe you can just tell us where we are, and there's less new than usual, I think.
Short breath, quick breath. All right, thanks, Pete. So last week, when I had the privilege of speaking on this webinar, we talked about the Paycheck Protection Flexibility Act, which was the new legislation put into effect that changed certain requirements of the PPP. So at that point, I had indicated that we were waiting on a few things. We were waiting on new guidance from the SBA, both clarifying the PPP and how it was going to, the Paycheck Protection Flexibility Act, and how it was going to interpret some of those requirements, but also really updating previous guidance that the SBA had previously issued, because now some of those changes that the PPFA made to the PPP were now inconsistent. So just as Pete said, I wanted to provide an update today about where the SBA is in that process, what we know, what we're still waiting on, and then we've seen a lot of questions come in the past week about the changes and how it affects borrowers and their covered periods. So I want to take a couple of minutes at the end and answer some frequently asked questions that we're seeing. Okay, so without further ado. Last week, we did start to see the updates come in from the SBA regarding the guidance. So what we got last week from the SBA was an update to the April 2nd first interim rule that they issued, along with an updated loan application. So what did this do? Okay, first, the updated guidance clarified the maturity date for new loans compared to old loans. So loans that were obtained prior to the PPFA going into effect still have a 2-year term date. New loans that are obtained after the PPFA went into effect have a 5-year loan term date. So that is a clarification that we did see. The guidance also clarified what the 10-month repayment period looks like. So the PPFA put language out there indicating that borrowers have 10 months to start making payments on their loan. So what this guidance did was it gave a really solid example that I'm going to go through here in a minute. And it explained that borrowers have 10 months from the end of their covered period to use their funds to apply for forgiveness. If they haven't applied for forgiveness at that point, it's not saying you can't still apply, but if you haven't done it at that point, then you have to start making payments on the loan. So let me give the example. So if a borrower receives their loan disbursement funds on June 25th, they choose the 24-week covered period, then those 24 weeks would end on December 10th, 2020. The borrower then has to submit for forgiveness by October 10th, 2021. If they haven't done that, then they have to start making payments on October 10th, 2021. If they've submitted, let's say, for forgiveness on October 1st, it seems like since they've submitted for forgiveness, the SBA has 60 days to review the forgiveness application and determine if they're eligible or not. It sounds like the borrower wouldn't have to start making payments at that time because they have submitted for it. But if they haven't, then they would have to start making payments. So the SBA did clarify that. The big thing in this guidance is this idea of the 60-40 split of payroll and non-payroll expenses. So last week I talked a little bit about this discrepancy and the PPFA and how some senators were concerned that it functioned as a cliff. So what do I mean by that? If a borrower uses less than 60% of payroll expenses, are they prohibited from receiving any forgiveness? The new guidance issued last week makes it clear that that is not the case. So in the event that a borrower uses, let's say, 50% on payroll, 50% on non-payroll, they would still be eligible for forgiveness, but it's just their forgiveness amount would be reduced based on using less than 60% on payroll expenses. So that has now been clarified by the SBA. The guidance issued last week reiterated allowable uses for the PPP funds and certain certifications that borrowers are making. The SBA also relaxed certain prohibitions on owners with certain criminal convictions obtaining loans. Okay, so where are we now? We are still waiting on a new forgiveness application, and we are still waiting for updates to the interim rule on loan forgiveness. I suspect because there is so much funding left in the PPP program and the time period to obtain a new loan ends on June 30th, the SBA, it's my impression that they had updated the guidance that they did regarding the first interim rule and the new loan application first because of that looming timeline for borrowers to get new loans. So we are still waiting on more forgiveness guidance, and hopefully we see that soon. Okay. So, like I said, in the past week, we've seen a lot of questions. I did a Facebook Live interview last week, and we got some great questions from that interview, and that we've heard some of the same questions come up in the past week. So now I want to take a couple of minutes and go through some of those questions that we've received. Okay, so one of the first questions we got was, can I choose between the 8-week period and the 24-week period? Yes. The guidance that was issued last week from the SBA seemingly indicated that it's a 24-week period, but borrowers can choose to do an 8-week period. It still use the old 8-week period. We don't know yet, though, how a borrower makes that choice. It's my guess that that's going to show up in the loan forgiveness application, that there's going to be some sort of box check, but we just don't know yet how that affirmative choice is made. Next question, does the $15,385 cap still apply? Unfortunately, we don't know. So that cap was originally based on the idea of an 8-week period at a $100,000 annualized salary. Not paying more than that. So that's where we got that number from. We don't know if that cap now, for borrowers who choose to utilize a 24-week period, if that cap is going to be heightened in proportion to the new 24-week period. That's something that's still outstanding. All right, the next question we received was about the 40%, 60% split. So the question was, does the 60% payroll expense apply to old loans or only new loans? It does apply to old loans. So this is for anybody who has a PPP loan. You now have the benefit of the 60% payroll expense threshold. Okay. Next question we received was, can the 24-week period be cut short when the money runs out? So right now we are seeing a situation where borrowers really obtained loans based on 2.5 months worth of payroll expenses. So in some cases where borrowers either had employees who were furloughed and didn't bring them back right away, or were closed and didn't have any employees brought back, they now are in a position where they need the extra time to use the money. But they don't maybe necessarily need the full 24 weeks. In some cases, they only need 10 weeks or 16 weeks or 20 weeks. So we don't know yet if borrowers need to utilize the full 24-week period, or if they can apply for forgiveness after their funds run out at, say, the 10-week mark or the 12-week mark or the 14-week mark. That's still an open question that hopefully we see in the updated forgiveness guidance. Another question that we've been seeing for borrowers who have used up almost all of their funds under the old rules, can we apply for a second loan? Although applications are still open for new loans, borrowers who currently have loans cannot apply for a second loan. There's only one disbursement of PPP funds unless you fell into a certain exception for owner compensation that we've previously talked about. There's only one disbursement, so no secondary loans, only new loans for borrowers who have not received PPP funds yet. And then the last question that I'm going to address today is, does the EIDL grant count against forgiveness? So the EIDL is something that we haven't really talked a lot about on these webinars. It's been really focused on the PPP. And the EIDL is another program by the SBA for certain funds. At this point, we're starting to see borrowers receive their loan documents for that program. And part of that program was a grant. And that grant provided X amount of funding by a grant form that does not need to be repaid under the EIDL program to borrowers. However, if a borrower does receive an EIDL and a PPP loan, the amount of the grant under the EIDL that the borrower received will be factored into the PPP forgiveness calculation. So that is an interplay that we are keeping our eyes on, that borrowers should also keep their eyes on if they have received both funding. So that is what I have for today. We are keeping our eyes on the SBA website to see when they will release the new forgiveness application, the updated application, and hopefully updated guidance here shortly, and we will update you when we see it. Thank you.
Thanks, Kate. Appreciate all that. A lot of information in there. I think that's going to do it for us for today. We'll be back here next week with another update, and we're also going to take a couple of your questions offline and post some short videos on those travel questions and the interplay between the liability issues and the OSHA issues and the comp issues. So please look for those. If there are other questions that you have, please don't hesitate to contact your bond attorney. Thank you very much for being with us today, and everybody stay safe. We'll talk to you soon.